Rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear ye, hear ye. All persons having business with the Appellate Division. One here, give your attendance, and you shall be heard. You be seated.
Good afternoon. Welcome to the Appellate Division First Department. We have some 6 hours of argument that has been requested, so please bear that in mind as I call the calendar. Please keep in mind that we have the records, we have your brief, we're fully familiar with the facts of your case. So ask only for the time that you'll need to make your most important arguments, okay? First case is People versus Robert McCoy, submitted. Soto versus Shea. Soto versus Shea. Are you one of the parties, sir? I'm requesting the time you want. 5, 2, and 5. Thank you. 13 Harris Street versus Bleich. Bleich. 5, 2, and 5. Thank you. Douglas versus Tishman Construction. Is a cross appeal here, I believe? Well, who's the appellant here? Okay, we'll start with you. Yes, we're going to do it all at once. Yes, you'll have, what time are you asking for? So, okay, what time do you want for your argument and what time do you want for your rebuttal? Okay, thank you. I will give 6 and 2 and 6 and 2. American Construction versus Shiraka and Ozimo.
Yes, Your Honor. For appellate, I request 8 and 3.
3 minutes, you said? 4 and 2 and 3. Burlington Insurance Company versus 54th Street Auto. Submitted. RFLP versus 255 West 98th Street.
For appellate, 5 and 2, please, Your Honor.
5, 2, and 5. New York State Construction versus New York City Department of Health. Who do you represent? Okay, submission. Thank you. Rubio versus Ezra Cohen.
For the appellant, I understand the respondent will not be here, so unless the court has any questions, we will submit.
Okay, thank you. Submission. Pimentel versus DeFreight, and there are 2 cases on the calendar.
For the appellant, respondent Namor, 3 and 1. For the cross appellant PEI, 4 and 1. Plaintiff respondent 4 minutes.
Okay, thank you. People versus Roderick Kovlin.
For the account, at this time I'd like to make an application under section 1250.1B of the rules of court. Is this the appropriate time to make it?
Yes, sure.
If a fifth judge is subsequently assigned, I'd like to have an opportunity to argue before that judge 5 minutes, if appropriate, be in time for the court.
Okay, thank you. Yes? I'll give you, let me just see, 8 and 3 and 8. Yume versus New York City Health and Hospitals is submitted, and Thoreau versus Resnikow is submitted. The first case for argument is Soto versus Shea. You may begin.
Good morning, Your Honors.
Afternoon, but I know it's,
Good
I'm
afternoon.
glad you're feeling so energetic that you think it's morning.
My name is Tim McEnany from Goldberg and McEnany, or the appellants. May it please the Court. Briefly, this appeal is from the denial of an Article 78 proceeding challenging an administrative agency's denial of Officer Soto's disability pension application. There are two main issues I'd like to begin with. The first is as to which right elbow injury caused Officer Soto's disability.
What's the year of the injury? Is it 2012 or was it 2016?
Both years.
But
2012 was the
which is
first
the injury. Which is the injury that supports the claim for the ADR?
2016, actually both do, Your Honor, but the 2016 in particular.
Thanks.
But
2006
the trustees came to a conclusion that the 2012 results in an ordinary retirement, didn't they?
They sure did, Your Honor. That was incorrect. The reason that it was incorrect is
So
that he
what was it
returned.
about the fall on the floor of the 76th precinct that turns this into an accidental disability?
I'm sorry, Your Honor, could you repeat?
I said, what was it about the fall on the floor, the slip on the floor at the 76th precinct that makes this other than an ordinary disability?
If that were the disabling injury that he suffered, Your Honor, under the Court of Appeals case law and the cases set in our brief, and this First Department court's case law, slipping on a hazardous substance on a floor is an accident for pension purposes. The Court of Appeals has held this in the case of a puddle on a bathroom floor where one might expect to see water, and it's also been held in that case.
So when does the water come in this case? When is isn't there at some point a claim that water was tracked in from a snowy condition? Is that?
That's correct. There were
But that doesn't come into the case until 2019, isn't that so?
I didn't catch it.
Doesn't that factor not get alleged until 2019?
Yes, that's true, Your Honor, but it was a contemporaneous record that was adduced. The record had been made in 2012 that there was, in fact, a 7-inch snowstorm that day. There are multiple contemporaneous witness reports stating there was, in fact, water on the floor where he slipped. And it was confirmed by their own medical board that he did injure himself that day during that occurrence. Under Court of Appeals case law, it's very clear this is an accident for pension purposes. So if it was that accident that disabled him, he qualifies for 3/4 disability pension. If it were the 2016 accident, which occurred during an arrest, where he hyperextended the same elbow, that occurred after 2.5 years returned to full duty, 2 years returned to full duty. So he was performing the duties of a police officer fine.
But it seems like there was not clarity with regard to the way the accident happened, at least in the record that was presented to the board.
Which action are you referring to,
The
Your Honor?
2016 action. Actually, it's kind of muddled as far as the 2012 accident as well, whether there's dust or some substance on the floor that causes this.
Well, there's no
whether there was
question
some
that there was
water,
a
but-
substance on the
but just
floor.
let me finish.
Oh, sorry.
But it seems that there lacks clarity in the record as to the facts that caused the 2016 injury. And please put your mask up over your nose.
Okay, so for the 2016 injury, That injury was authorized, the surgery for that injury was authorized by the NYPD's own medical division, which found that it was caused by that altercation. The NYPD's own medical division.
Yes, no, you're correct. They found that his falling on the floor, slipping on the floor, was the cause of the elbow fracture and whatever else happened. But the question was, for the purposes of whether that was a service-related injury, that's what I'm saying. That was rather muddled as to what the actual cause of the floor was. Not that the slip and fall did not cause the injury. It did cause the injury. Clearly, he fell and he injured his elbow.
So there is some issue of fact as to whether it was dust or dirt, let's say probably sand from the snow outside, or water that caused him to fall. It is perfectly understandable that some would see.
But the trustees decided, whatever the cause may have been, that the accident, if you want to call it that, or the injury resulted from petitioner's own misstep. Isn't that how the Board of Trustees characterized it?
It is, and that is violative of Court of Appeals
And
case
for pension
law.
purposes, it didn't support an ADR.
That's what the Board of Trustees held incorrectly, Your Honor. In fact, in all of New York State, if you slip on water in a station house or in a bathroom in a station house, that is an accident for pension purposes. That's Court of Appeals. The Board of Trustees likes to follow third department case law, which is much more restrictive than this department's case law has been, which is takes a more liberal view of what constitutes an accident, I think appropriately. But that is not the controlling case law here. So
Thank you.
If it were the first department, I'm sorry, if it were the first accident in 2012, he slipped on a substance, a hazardous substance, on the floor. No one who's testified about what was on the floor said there was nothing there, that he slipped on clean floor. That's what a misstep would be. Here, it was an extraneous factor, a foreign substance that he slipped upon, that he could not have been aware of ahead of time.
Thank you, counsel. You have rebuttal.
May it please the Court, Cleveland Henry on behalf of the Police Pension Fund. The Board of Trustees properly denied Soto ADR benefits.
Does slipping on water in a station house mean that you get an ADR?
You know, he'd certainly have a stronger case if he could establish that as a matter of law, which is his burden to prove that there was water on the floor, but he can't establish that on this record. And he continues to talk about him slipping on water, but the contemporaneous injury report of the incident includes 4 separate accounts. 2 say he slipped on water, 1 says he slipped on a dry but dusty floor, and his account says nothing about the condition of the floor. And the same is true of the emergency room records. There are different accounts. 1 says the floor was wet, 1 says the floor was dry. And when the Board of Trustees is faced with those divergent accounts, it's within its discretion to conclude that the floor was not wet, in which case it was a misstep. Again, it was petitioner's burden to establish as a matter of law, and that's not something he can do on this record. And as a result, the first incident, while that undisputably resulted in his disability, is not an accident under the pension laws. With respect to the second incident in 2016, there was simply no evidence no objective medical evidence of that incident exacerbated his elbow condition to the point of
Well, there certainly was evidence, it seems, that the incident exacerbated his injury. I thought it was that it wasn't clarity as to what the incident was. He had a doctor, I believe, that says that he had issues with the elbow after that incident.
No, Your Honor. I mean, the disabling injury was his ulnar nerve damage, this numbing and tingling in his arm, and that injury, that disabling conditioning long predated his second incident. Now, he reports that his second incident made that injury worse and resulted in disabling him, but the medical board, which is an independent body comprised of its own independent physicians, is not required to accept his subjective reports about the state of his elbow following this second incident. And so what we have here is we have objective medical evidence establishing that his fall in the precinct was the result of his disability, and the conflicting accounts about the circumstances of that fall led to a rational conclusion that it was a mere misstep, which, as a matter of law, is not an accident. And this court has held on several instances, on several different occasions, that a mere misstep is not an accident for pension purposes. If there are no further questions, thank you, Your Honor.
Thanks.
The 2016 accident was the cause of his disability. Officer Soto performed full duty for 2 years following his 2.5 years of treatment for his initial elbow injury with no issues up until the date. He may have not been asymptomatic, he had some symptoms, but he returned to work and was able to work full duty. He was ordered back to full duty by the NYPD's own physicians. After he returned to full duty, he gets into an altercation, hyperextends his elbow, and it gets to the point where he can't take it anymore. He then has to get a surgery. The surgery is found to be disabling to him. Up until that injury in 2016, he had no problem working. He was capable of full duty. He clearly was not disabled. The only factor that changed was after that point. He may have had issues with his ulnar nerve, but he was still performing his job responsibilities without a problem. It wasn't until after this exacerbating injury that he had the problem. And the medical board failed to even consider a Tobin analysis, even after the Board of Trustees saw the issue and said, you need to think about whether this exacerbated his 2012 injury. Then the Board of Trustees, after seeing the issue, despite the fact that the medical board ignored the issue, ratified the denial. That is arbitrary and capricious.
Thank you. Thank you both.
Your Honor.
Yeah, I'm sorry. 13 Harrison Street versus Bleich.
Good afternoon, Your Honors, and may it please the Court, Leonardo Trevino of Carter, Ledyard, and Milburn, on behalf of plaintiff appellants 13 Harrison Street Condominium and 13 Harrison LLC. Your Honors, this dispute concerns the owner of, the 75% owner of the condominium, 13 Harrison LLC, and respondents who own 25% of the condominium. The only issue on appeal here today relates to appellant's fourth cause of action, seeking a declaratory judgment that respondents violated the governing documents of the condominium by maintaining bedrooms and bathrooms in the cellar portion of their unit.
Counsel, can you show me where the certificate of occupancy forbids the presence of a bathroom in the cellar? Because it seems to me that your argument assumes that if there's a recreation room, there can't be a bathroom adjacent to it for the use of the people enjoying the recreation room. Is that your position?
Absolutely, Your Honor. So if you look at the...
So where does the C of O say that?
Well, the C of O, and this is on SR2, clearly delineates that the first, second, third, and fourth floors can be used for
No,
loft.
I understand what it says affirmatively. I'm asking what in the C of O or the declaration forbids the presence of a bathroom in the cellar.
Well, a rec room, the plain meaning of the word recreation room, is, I guess I'd answer that in two ways, Your Honor. One, the plain meaning of the word recreation room.
Well, it's so funny. I would assume a recreation room involves people enjoying themselves and maybe having something to eat or drink, and they might want to use a bathroom. Are you saying that they can't have a bathroom adjacent to or part of the recreation room?
That's my reading of the C of O.
And where does the C of O say that anywhere?
It doesn't say that expressly,
And
no.
is there an administrative code provision that says a recreation room can't have a bathroom in it?
Not that I'm aware of, if I may. But the problem with the cellar is twofold. It's both the bathroom.
I was asking you about the bathrooms.
Okay, yes, Your Honor. Then I believe I addressed your questions. So the issue here is whether respondents have improper or have violated the governing documents of the condominium by the maintenance of bedrooms and bathrooms. Now, we've submitted...
And what in the declaration forbids bathrooms as part of or adjacent to the recreation room?
Well, the declaration mandates all unit owners comply with the rules and regulations.
So what rule or regulation would forbid the presence of a bathroom in a recreation room?
I think that goes back to Your Honor's prior question. My read of the C of O, I would say the C of O, I understand Your Honor may have a differing view, but again, just to reiterate, the problem with the cellar goes beyond the presence of the bathroom. And I think it's crystal clear, both in the New York City Administrative Code as well as in the C of O, that bedrooms are not permitted in the cellar. And
So for the presence of the bedrooms, you rely on the existence of the floor plan, right?
in part, yes, we rely on actually three things, Your Honor. One is the
Could you tell me are you claiming that the real estate agent could authenticate the accuracy of a floor plan?
So the real estate
I didn't
agents.
see any other way that the floor plan could be authenticated apart from the statements of the real estate agent.
By the statements of the real estate agent, but the real estate agent was the one who visited the premises. So he can attest to whether the floor plan was accurate. And he says that in his deposition testimony.
He didn't measure it, right? He doesn't claim that he measured it?
No, not accurate to a mathematical certainty, but accurate
So how
to,
do we know if it's not accurate to a mathematical certainty that it's accurate in other respects?
because he personally witnessed the bedrooms and the bathrooms in the cellar. And he testifies to that at his
The fact that
deposition.
he witnessed something is different from authenticating a document, isn't it?
He spoke to and testified to the accuracy of the document, of the floor plan.
But not
but in
as
it-
to the numbers in it, not as to the actual dimensions, right?
I don't believe he testified to the actual dimensions of the floor plan, no. But beyond, the relevant issue here is whether there are bedrooms in the cellar. And
Is this an issue which requires fact-finding as to just what the situation is and whether it's in violation of the certificate of occupancy?
No, it does not require fact-finding because the evidence that we've submitted, the record, is unrebutted. And in fact, the respondents don't deny that they have bedrooms and bathrooms in their cellar. You can search in vain the record, but there's no denial from respondents, nor is there any.
But they don't agree that that's a violation of the certificate of occupancy.
That's correct, but that's more of that's an issue of law for the court to decide. And when you look at the certificate of occupancy and you look at the New York City Administrative Code, it's not a hard decision. It's not a hard call.
Thank you.
Thank you, Your Honor.
May it please the court. Robert Jacobus, Lazare, Potter Jacobus, and Moyle for the respondents. I'm going to be very brief, really in response to panel's question to my adversary. Page 11 of the opening brief of the appellant puts the fundamental question on this appeal, on their summary judgment motion, this way. It says, whether appellants are entitled to summary judgment turns on a legal, not a factual question, and they write, does the declaration prohibit bedrooms and bathrooms in the cellar portion of the respondent's unit? And the next sentence of their brief on page 11 says, the declaration on its face prohibits such use. Clearly, it doesn't. Clearly, the certificate of occupancy does not prohibit the use. And then they rely upon, you've got to search, you've got to determine factual issues, and then you've got to go to the New York City Housing Code, and the Housing Code talks about ventilation and recreation rooms, and as the panel pointed out, says nothing about bathrooms, only about sleeping. So what does that mean?
Well, counsel, I actually have a question about that. So why doesn't the presence of sleeping areas in the cellar contravene Section 27-2087 of the Administrative Code?
Because, Your Honor, there are other sections of that same code which were not explored through expert testimony in the lower court. Because the C of O says it's a recreation room and can be used as such, there are other provisions of that administrative code that say if there's proper ventilation, if there's proper lighting, if there's proper egress, if the dimensions are a certain way, it can be used for habitation. And the question, even at oral argument before the lower court, my client was sitting in his room, in the lower level of this unit, in the recreation room. There was natural light, there was egress. These are all factual issues that were never determined below, that are not appropriate for summary judgment. And this is why the court, and we cited this, it really was a matter of Karakash, and it's a First Department decision, said A declaratory judgment is discretionary, and this is why ultimately the lower court dismissed their claim, fourth cause of action, for summary judgment, seeking this declaratory judgment, and it also sought a mandatory injunction, which was never explored, never addressed. What does it mean? Even assuming, Your Honor, that you can't sleep in the bedrooms, does that mean that just if they remove the beds, the bathrooms are perfectly permissible? Is that in compliance? They don't say so. I don't know. The lower court said this is inappropriate for summary judgment. You're not entitled to a mandatory injunction, and dismissed the fourth cause of action. And that decision was correct, and it should be affirmed on appeal. If the panel has any further questions, I'm happy to address them.
Thank you.
Just very briefly, counsel mentioned that the other provisions of the New York City Administrative Code weren't explored. Well, I mean, to the extent that he believes that there are relevant provisions, he had an obligation to come forward with them. The only thing that he references in his brief are, a question about whether the cellar is a habitable space. But that's not the issue, and that's a complete red herring. The issue is, can you, and I think one of Your Honors asked the right question, can you sleep in the cellar? Can you have bedrooms in the cellar? And the New York City Administrative Code, as well as...
Can you have rooms in the cellar?
I'm sorry, Your Honor?
Can you have rooms in the cellar? I think he's alluding to the fact that if you take the beds out, you still have rooms if there's ventilation, space, egress.
I'm sorry. That may very well be, but the issue here is whether they can have bedrooms in the cellar. That's what our declaratory judgment sought, and that's what we seek to rectify. And the New York City Administrative Code, the provision we cite, makes that crystal clear. And unless the panel has any further questions.
I have a question.
Yes.
So you're relying, it seems to me, very heavily on Mr. Kornmeier's deposition transcript. But I'm looking at the end of it, and he never signed it. It's not notarized. Why isn't that a problem for us in terms of whether it's reliable?
It actually was, Your Honor. We submitted it as part of...
It was what?
It wasn't signed and notarized. It was submitted as part of our reply papers. I can find it in the record. I just don't have it handy. But it was signed and notarized.
But only in the reply papers?
Correct. That's why you don't see it.
Thank you.
Thank you.
Douglas versus Tishman Construction. You may begin.
Good afternoon, Your Honors, and may it please the Court. My name is Kristen Gianaris for the Plaintiff Appellant Respondent, Mr. J.D. Douglas. Plaintiff should not have been collaterally estopped from asserting his TBI injury in this litigation based upon what the Workers' Comp Board decided. And that's because the
Well, didn't the Workers' Comp Board decide this issue already, and wouldn't he now be collaterally estopped?
What the Workers' Comp Board decided was a procedural determination that the TBI claim could not proceed solely because the TBI injury was, quote, not referenced in the medical report submitted by plaintiff's neurologist. And that is not identical to and decisive of the precise issue in the personal injury litigation, which is whether the TBI injury was causally...
Isn't there a fair inference from Dr. Rubenstein's testimony that there wasn't a TBI?
That's true, Your Honor. However, that testimony was never relied upon by the workers' comp judge in denying the TBI claim. That the only sole articulated...
And how do you know that?
Well, the decision, I believe, speaks for itself. If you look at page 283 of the record, the only sole articulated reason for the denial of the TBI injury is only because of what appeared in the plaintiff's report submitted by his neurologist. It had nothing to do with Mr. Rubenstein, Dr. Rubenstein's testimony. And in fact, if you look at page 284 of the record, you'll see that the workers' comp judge actually took care to notate specifically when and where he was relying on Dr. Rubenstein's testimony. So you'll see that he relied on it and specifically pointed out when denying further cognitive treatment. And he also did so in the paragraph below when he found that there was no further causally related injury. that's conspicuously absent from the portion of the decision denying the TBI claim. And it behooves the defendant to argue that this was actually the stated basis for the judge's decision in denying that claim when it's actually contradicted by the plain text of the decision itself. And if your honors even have any doubt or any question as to the basis for why this claim was denied, then this court should find that defendants failed to meet their burden as they carry the burden of establishing that the issue decided by the board.
Didn't the workman's comp judge disallow the TBI because Dr. Kwan did not include such diagnosis in his medical reports?
That's true, Your Honor, and Dr. Kwan added deposition explained, just for context here, that was not included because there was no CPT code which corresponded to the TBI injury. But again, the only stated basis for the denial was this procedural-based ground that it didn't appear in his medical report, not that there was a substantive determination on the merits that this injury was not causally related to the accident. And absent any such finding, we submit that the collateral estoppel doctrine was simply inaccurately applied here. So we submit that the portion of the order appealed from be reversed. Any further questions from the panel?
No, thank you.
Thank you, Your Honors.
Your Honor, Kevin Pollack from Fabiani Cohen Hall on behalf of the defendants, appellants. I think I'm supposed to respond to the appellant's appeal, so I'll do that very quickly first before I get to mine. And very quickly, in the workers' comp decision, the judge indicates that he's basing his decision based upon a review of the evidence in the record. And the evidence in the record included Dr. Rubenstein's testimony, which the administrative law judge specifically cited to, so obviously was aware of it. Two of the plaintiffs' treating neurologists testified, claiming the plaintiff had a traumatic brain injury and cognitive disorder. Dr. Rubenstein disagreed, and I think it's clear from the decision as a whole that clearly the judge considered all of the evidence and came to the conclusion that the claim for traumatic brain injury and cognitive disorder should be disallowed. So I believe the plaintiff is collaterally stopped since he had a fair opportunity to litigate that before the comp board. In terms of the defendant's appeal from the granting of summary judgment, it is submitted that that should be reversed for several reasons. Primarily, or one of the big reasons, is that the plaintiff failed to prove as part of their initial burden that the defendants were labor law defendants subject to labor law liability. The plaintiff's motion failed to include the pleadings. Even if it did, the pleadings don't establish that they're labor law defendants. The plaintiffs did not include any deposition testimony of the defendants at all. The plaintiff's motion did not include the Tishman contract, which is nowhere in the record. The entirety of the proof that the plaintiff submitted in support of the motion was that was one line in their motion that the defendants, as lessee and construction manager, had a non-delegable duty. That's the entirety of the proof in terms of whether the BOP entity was a labor law defendant and whether Tishman was in fact even a construction manager.
Tishman was a construction manager and acted on behalf of an agent of the property owner, wasn't he?
No, there's no evidence of that in the record, Your Honor. There's nothing in the plaintiff's motion that establishes that even Tishman was a construction manager. And in opposition, as part of our motion, we necessarily had to include the pleadings to amend our answer, and we included the deposition testimony of Tishman's witness, which I submit does not establish that it's a labor law defendant. But in any event, the plaintiff takes the novel position that they can rely on the evidence we submitted in opposition to meet their initial summary judgment burden, which is contrary to Court of Appeals authority, contrary to authority from this court on that issue. They cite the 3 cases, 2 from the Second Department appellate term, 2 no-fault cases where the court did apparently allow opposing evidence to be used to meet the plaintiff's initial burden, which is clearly wrong and shouldn't be followed by this court. They also cited 1 case from this court 30 years ago, which seemed to hold that as well in a mortgage foreclosure action. At that time, that case has never been cited again by this court in 30 years, and that statement in that decision didn't cite any case law to back up the use of the opposing evidence. So it's submitted that the proof that the plaintiff used in support of their motion to establish that the defendants were labor law defendants was simply one assertion, unsupported by evidence by plaintiff's counsel, which is insufficient to meet the plaintiff's summary judgment burden, and the plaintiff cannot rely on our opposing evidence to meet their initial burden. It is also submitted that in opposition, the defendants raised an issue of fact regarding sole proximate cause by submitting the affidavit of the safety manager, who indicated that right after the accident, he spoke to the plaintiff, who admitted that he helped carry this door form with coworkers to a position right behind him, left it unsecured. It's an admission by the plaintiff, and we think that raises an issue of fact of sole proximate cause, which also warranted the denial of the summary judgment motion. I mean, you don't even need to get to that issue if you rule in our favor on the plaintiff's failure to establish that the defendants are labor law defendants. And finally, in terms of the industrial code sections, submitted that the judge was wrong on that issue as well. Since the door form wasn't being used at that point, it was just simply standing there. It was removed so that other work could take place. There was no concrete work taking place. There's no predicate for the applicability of either of the industrial code rules upon which the judge granted summary judgment in favor of the plaintiff. It's therefore submitted that the court should be reversed on its summary judgment in favor of the plaintiff on liability and should be affirmed with respect to its finding that the plaintiff's collaterally stopped regarding the traumatic brain injury and cognitive disorder claims. And if there's no other questions, I will sit down. Thank you, Your Honors.
Thank you.
I'd like to just briefly address the cross-appeal arguments. Here, I think it's important to note that the issue of defendants' labor law status was never actually disputed by the parties here. Defendants didn't move for summary judgment on the basis. They never argued that they weren't proper labor law defendants. And there is precedential support in this department for the notion that opposition papers can be perused for the limited purpose of curing a deficiency in the moving papers. And although that rule is uncommon, we acknowledge that. Here, since the issue of defendant status was never even disputed, we submit that this is a proper situation for that rule to be applied. And when you look at the defendant's submissions in opposition, you have an admission in the answer that defendant BOP leased the property in question and contracted with Tishman. And as we elucidate in our brief, Tishman's deposition witness testified to his broad responsibility in coordinating and supervising this entire construction project. And we submit that those two pieces of evidence were sufficient to establish that defendants were proper labor law defendants in this situation. And finally, with regard to the sole proximate cause argument, we submit that this court should outright reject the affidavit for Mr. Cleary. This was an affidavit submitted 3 years after the accident and contained a new version of the accident now that never appeared in the contemporaneous accident report 3 years prior, and now blames plaintiff for the accident. The fact that this suspiciously emerges 3 years after the accident for the purposes of a summary judgment motion renders this affidavit inherently suspect and clearly failed to raise an issue of fact. So we submit that this should be rejected outright, and it fails to raise any question of fact as to sole proximate cause. There are no further questions. We'll rest on our briefs.
Thank you.
Thank you.
Yes, 2 minutes.
Again, the plaintiff just argued that since we didn't cross-move for summary judgment on the ground that the defendants were not labor law defendants, that somehow eliminates their initial burden on their motion from establishing that the defendants are labor law defendants. And that's just not legally supportable. There's no case law that says that. They just say that. And again, in terms of the case law they rely on in terms of opposing evidence meeting the movement's burden, as I said before, 2 of those cases are from the Appellate Term Second Department, which simply are wrong. And again, the First Department case, the Bowery Savings case, from this department, it was a mortgage foreclosure action, and the admission, in that case, this court relied on very specific, concrete admissions in opposition and allowed that to serve as to meet the plaintiff's burden. Again, as I said, that the First Department did not cite any precedent for that proposition. This department has not cited that case again since that case 30 years ago. And if the court was to consider that First Department case, the admissions or the type of admissions that that court said were proper to use are not present here. There are no such admissions here by the defendants in their opposition. Thank you, Your Honors.
Thank you. Thank you both. American Construction versus Scirocco and Ozimo.
Good afternoon, Your Honors. May it please the Court, my name is Matthew Quinn of the firm of Quinn McCabe, attorneys for third-party defendant appellant Thornton Tomasetti, Inc. This is an appeal of the decision and order of Justice Ostreger, which erroneously denied Thornton Tomasetti's motion to dismiss Respondent L'Aquila's Group amended third-party complaint pursuant to 3211A7 and erroneously granted Respondent American Construction motion for leave to file an amended complaint. This is a breach of contract action between a construction manager and its subcontractors, plain and simple. The trial court's refusal to reject the respondent's attempt to make this more than a breach of contract action is an error and should be reversed. There is absolutely no basis for any tort-based claims, and even if they are barred by the statute of limitations, as the trial court found and ruled subsequent to the order which is the subject of this appeal. There is no dispute that American's negligence claim is time-barred. The American's complaint and the amended complaint both allege that the incident occurred on November 17th, 2016. American filed its original complaint on December 3rd, 2019, more than 3 years after the date of the incident. Therefore, any tort-based claim was already time-barred as of the filing of American's original complaint. Therefore, in evaluating L'Aquila's third-party complaint, American's negligence claim should be completely disregarded, leaving the focus solely on American's claim for breach of contract. Let's take a look at American's claim for breach of contract, the allegations of which are identical in both American's original complaint and in its amended complaint. American's breach of contract cause of action seeks only economic loss damage, including substantial costs and expenses, including costs to complete and costs to correct deficient and non-conforming work, costs resulting from delays attributable to the incident and the project shutdown.
So it's your position there's no basis for them to assert contribution or indemnification against Thornton?
That's exactly right, Your Honor. It's clear that the breach of contract action is only for economic loss damages, and all damages that are alleged in the breach of contract cause of action were contemplated by the parties at the time they entered the L'Aquila subcontract. So, pursuant to controlling New York law, there's no basis for a claim for contribution against third-party defendant Thornton Tomasetti. The case law interpreting New York's compass is clear that purely economic loss resulting from a breach of contract does not constitute injury to property within the meaning of CPL 1401. The Chatham Towers case cited in our papers is clear that even to the extent that there's damage to property which is not the property related to the work of the defendant, as long as it's contemplated in the contract, it does not constitute injury to property within the meaning of New York's contribution statute. And therefore, because the only viable claim against L'Aquila is for breach of contract, L'Aquila's third-party claim for negligence against Thornton Tomasetti must be based on a relationship of privity of contract. There is absolutely no allegation, nor could there be in the third-party complaint, that there is any relationship between L'Aquila and third-party defendant Thornton Tomasetti.
Thank you.
That amounts to privity of contract or the functional equivalent thereof. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Irina Kravchenko, I represent defendant, third-party plaintiff, respondent L'Aquila on this appeal. It is L'Aquila's contention that the Supreme Court correctly denied Tomasetti's motion to dismiss pursuant to the liberal pleading standard that is applicable to this type of motion. This Court has clearly...
What relationship does L'Aquila have with Thornton?
There's no contractual relationship between L'Aquila and Thornton. The determination...
Well, counsel just said there's no privity between L'Aquila and Thornton. L'Aquila is not the company that hired Thornton, it was the architect. So can you address the issue of privity?
Your Honor, it is L'Aquila's position that privity is not the issue, the controlling issue, because the underlying complaint does not simply allege economic damages. It also alleges property damages. Therefore, that analysis is not applicable. This Court has clearly stated that whether contribution claim survived is based upon the underlying, not the nature of the underlying complaint, but the measure of the underlying damages. The amended complaint in this
There's a contract here controlling. So there's economic damages.
Yes, Your Honor, there is a contract between American and L'Aquila. However, American also expressly alleged in its amended complaint, and I quote, that there was property damages and to the building core, loss of use of certain areas of the building, damage to other project work, separate and distinct from L'Aquila's installed work under the subcontract.
The only cause of action was a contract claim cause of action, correct?
Your Honor, the amended complaint clarified...
I understand, but the amended complaint, to the extent it seeks claims based on negligence, why aren't those all barred by the statute of limitations?
Your Honor, it is L'Aquila's position that to the extent that the amended complaint claims do not survive summary judgment or are not ultimately viable, that's not the controlling inquiry in this juncture.
Well, so, I'm sorry, you're saying that if a motion to amend is made to add claims that are palpably improper, the court has to permit them? I mean, if they are on their face barred by the statute of limitations, why would the court waste everyone's time by permitting that?
Your Honor, I would just like to point out with respect to the amendment is that the Supreme Court expressly granted Tomasetti an ability to make a motion against the pleadings in the future, which actually is the subject of the motion.
I understand that, but do you agree that the tort claims by American are barred by the statute of limitations?
Your Honor, I think that is L'Aquila's position, and that ultimately, yes. However, I would like to say that, let's put it this way, outside of the amending complaint, plaintiff's initial allegations that do not expressly state the cause of action of negligence, they actually also seek property damages. And they seek damages to the property, and they mention specifically, in addition to liquidated consequential, other damages.
So are the property damage claims based on contract or tort?
Your Honor, it is, if I may answer, I see my time is up. It is L'Aquila's position that based on plaintiff's allegations, to the extent that they stand, there are property damages claims, and whether they're artfully stated or not, for the purposes of motion to dismiss, as long as those claims exist, L'Aquila's third-party complaint for contribution survives.
Thank you.
Thank you very much.
Thank you. I think Your Honors have honed in on the crux of the situation. Unfortunately, L'Aquila is trying to have it both ways. The other defendants have moved to dismiss once the amended complaint was entered and filed. They moved to dismiss the negligence claim based upon the statute of limitations. Those motions were granted. L'Aquila has not moved. They say, yes, ultimately it will be dismissed because it's barred by the statute of limitations. But the only reason they're not moving to dismiss the negligence claim now is that they have some arguable basis upon which to rely on their third-party claims against Thornton Tomasetti. The only underlying claim is one for breach of contract. Any negligence or other tort-based claim is barred by the statute of limitations. Therefore, there is no basis for claims for contribution or negligence against my client, Thornton Tomasetti, and we respectfully request that the order denying our motion to dismiss be reversed.
Thank you.
Thank
Thank
you.
you both. RFL PLC against 255 West 98th Street. You may begin.
Good afternoon, Your Honors, and may it please the Court. Donnie Schwartz of Wachtell Mystery LLP for the Appellant Cooperative. Supreme Court's rationale for declaring the respondent a holder of unsold shares was wrong and unsupportable. Because the rationale was wrong, the decision was wrong. Supreme Court took the undisputed, conceded treatment by the co-op of the respondent as a holder and held that it was a gotcha, quote, almost an amendment of a contract.
So you're claiming that the plaintiff is not the holder of unsold shares, but the offering plan grants the person who buys the shares from the sponsor, and this is the new sponsor that the plaintiff bought the shares from, declares that person the holder of the unsold shares. In addition, we have the amendment, the 21st Amendment, that says they're the holder of unsold shares. They seem to comply with the terms of the offering plan, and the condominium has held them out to be the holder of unsold shares since the inception of their purchase. So,
Your Honor,
why aren't they the holder of unsold shares?
the cooperative has not held them out to be holders of unsold shares since inception. Rather, the cooperative actually notified or even...
Well, for some time. Okay, I'll correct that. For some
Correct.
time, they've held them to be the
Absolutely.
holder of the unsold shares.
That's absolutely right, and it was not disputed. And that has never been the basis for a finding of holder status, and it's...
Well, what about the other factors I just
Sure.
mentioned?
So that was rejected in Rotblood and similar cases. With respect to the 21st Amendment that Your Honor mentioned, that was written and filed by RFLP. Of course, so a self-declared
Well, did anybody challenge it?
Well, at that, no. At that
Okay.
time, the cooperative was operating under the belief that RFLP's assurances that it was a holder were correct.
But that's 16 years ago. So even if they were, were under a mistaken belief for some period of time, at what point in the last 16 years did they decide it was incorrect?
Apologies, Justice Gesmer. At what point in the last 16 years, what?
Did they decide that it was not a holder of unsold shares?
That was approximately at the end of 2018.
And so why did it take them 13 years to figure that out if they suddenly, what made them suddenly decide 13 years after the 21st Amendment was filed that it was incorrect?
Well, among other reasons, as explained in the brief, the cooperative board is, volunteer non-real estate professionals. That's number one. Number two
We're all aware of that, and that's true of all co-op boards in the city, but that doesn't mean that they're not held to a legal standard of what they have to do.
That's correct. And in addition, though, other factors were RFLP's continued insistences and assurances that they were, in fact, the holder. And again, this court has never, and nor has the respondent pointed out a single case this court has never held that a party can acquire this status by virtue of laches, estoppel, or a waiver. And in fact, this court has rejected those very arguments. For instance, in the Rotblood case, where waiver was rejected, where there's a no waiver provision in the co-op's proprietary lease, as here, where estoppel was rejected, which was essentially what the Supreme Court decided this matter on, although disclaiming a basis of deciding the case on estoppel, that is the nature, the gravamen of the decision below. And so...
Beginning on page 49 of the record and continuing on to 50, 51 and beyond, and on page 657 of the record in the proprietary lease, and page 49 is in the declaration, there's a definition of unsold shares. In what way does the plaintiff not meet that definition?
Well, first, the plaintiff did not purchase the shares from the lessor, which is the co-op, or the sponsor itself. Were the sponsor simply to be...
But does the definition require that the purchase must come directly from the lessor? Isn't there provision for successor entities acquiring these shares, and the shares still retain their character as unsold shares?
Well, when the selling entity was a sponsor or a holder and designated the shares as such, that would be one way. However, there was a total failure to establish or prove by any coherent means.
You've got 3 apartments being held by the entity, no? It's not being lived in by the owners. Isn't that also so?
That is so.
So could you point us to what in these definitions contradicts plaintiff status as an unsold shareholder?
If I may answer, I see that my time has expired. One of the items that contradicts is, again, the fact that the respondent here did not purchase from the lessor or a sponsor as that is defined. And if the definition and distinction of a sponsor is to be eviscerated to be any seller, then that renders meaningless the remaining language enumerating different categories of persons.
So you're saying that the sponsor has to be the original sponsor?
The sponsor has to be the original sponsor or otherwise fit within a definition of a seller whose transfer or conveyance would qualify.
Would the 19th Amendment, in essence, cure that problem? Because the 19th Amendment refers to 198, refers to West 98 Units, LLC, as the holder now of unsold shares, and refers to it as the new sponsor. Would that 19th Amendment then cure that problem that you say exists?
If I may answer Justice Mendez's question, thank you, Your Honor. We would submit that alone would not be sufficient. Again, that amendment was authored by a successor owner of the shares and announced in its own right that it was assigning to itself holder status. So something more than a mere self-serving declaration should be required to establish it as a matter of law. It's certainly a proof that could be considered. Thank you, Your Honors.
May it please the court, my name is John McCarthy from Smith, Gambrell, and Russell LLP on behalf of the respondent RFLP LLC. I want to pick up with something that you just said about the 21st Amendment and the petitioner's reference to it being self-serving document. Attached to the 21st Amendment, the First Amendment filed by RFLP, were his client's 2020 audited financial statements. They're required to be attached to the amendments. It was attached, and in his client's 2020 financial statements, the year that my clients became the holder of unsold shares, it referred to them as the new holder of unsold shares. So all my client did when it submitted the 21st Amendment was confirm what his client knew in 2020 and what my client knew in 2020, which is that they were becoming the holder of unsold shares.
One of the involved parties disagrees with an amendment that's filed. What is the obligation of that party?
I believe that they should report it to the Attorney General's office. These amendments were submitted to the Attorney General's office. Copies were provided to the managing agent and to all the other shareholders in the building. And if the board felt there was something wrong with it, they had a responsibility. After all, shares are being offered for sale based on these amendments, right? The whole reason why you're filing amendments to an offering plan is so that there can be subsequent sale of the shares of the cooperative.
So does the board have a fiduciary duty to its own shareholders to object to an incorrect amendment?
I believe so, Your Honor. We didn't really research or address that issue, but I would say yes, if that was the case, but that wasn't the case. Mr. Rinsler met with them before. Everyone understood. You have before you 35 years of documentary evidence, amendments to offering plans, financial statements from his clients, contracts signed by 2 officers of his clients in 2004, less than 2 years after the transaction where my client became a holder of unsold shares, where they were described as the holder of unsold shares.
Sir, did the offering plan and proprietary lease provide an unambiguous definition of a holder of unsold shares?
Yes. And it's on page 50 of the record, where it says there's 2 different ways to become a holder of unsold shares. There's the first sentence, which is not applicable here, and the second sentence, which begins with the word also, and it says a purchaser, and then it has a sort of a parenthetical phrase where it excludes the people who fall under the first sentences. It says a purchaser who purchases shares allocated to 2 or more units for resale or investment purposes and does not occupy any of the units is a holder of unsold shares for the units that the purchaser does not occupy. There's no requirement that the seller be the sponsor or designated by the sponsor. There's no reference to it being any designation being required. There's no reference to anything in writing. Simply the purchaser of 2 shares for 2 or more units who buys it for investment purposes, who don't intend to occupy it. There's no dispute that it was bought for investment purposes and that it was never occupied by any of the people who owned the shares at question.
So it's your position that the plain language of that provision, which appears on page 50 of the record, makes clear that a holder of unsold shares need not have acquired them from the sponsor and does not need to be the sponsor.
That's absolutely correct, Your Honor. And I see my time is up. Unless you have any other questions, I'll rest on my papers.
Anything else? Thank you.
Very briefly in rebuttal, Your Honors.
How do you deal with what counsel read from page 50 of the record, the last paragraph on the page?
The way that I would address it, Your Honor, is to look at page 537 of the record, the cooperative's proprietary lease, which amplifies the definition of unsold shares and who could be a holder of unsold shares, and requires and adds additional requirements to qualify for that status. Among those requirements.
But page 657 of the record also has a definition of unsold shares, paragraph 38A.
That's right. That's the same.
And doesn't the plaintiff fit within that definition?
No, Your Honor, because number one, they didn't purchase from the lessor or the sponsor, and number two, to the extent that
It goes on to say, and shares held by a paragraph 38A, shares held by a purchaser who is not the sponsor.
shares.
Fourth line of paragraph 38A, what does that mean? And shares held by a purchaser who is not the sponsor.
If purchased from the lessor or the sponsor. So whether that provision itself is contradictory, that would be potentially an issue of fact, but the qualifying sentence for that series in 38A is...
Where does it say in 38A that it has to have been purchased from the sponsor? Because it goes on to say, or if a principal of the sponsor who purchased from the lessor or the sponsor shares allocated to 2 or more apartments for resale or investment purposes.
Right, just before the 2 or more apartments, it says who purchased from the lessor or the sponsor. So that's precisely where the plaintiff respondent would have had to establish that it had qualified under that requirement, which arguably is in tension with the language on page 50 that was previously read.
But that follows the word not, which applies, I think, to that phrase, which applies to not the sponsor, not a principal of the sponsor, not a nominee of the sponsor, and not a principal of the sponsor. So I think that's all who it doesn't apply to, but then it says, but it does apply to anyone who purchased from the lessor or the sponsor shares allocated. So I disagree with the way you're reading that sentence.
If I may respond very briefly
Yes.
in a sentence, Justice Gesmer, respectfully, I don't believe that it's possible for the reading just described to be the plain meaning, because that would eviscerate that list, because if shares would qualify, then the shares would qualify to be purchased from anyone, any entity, any seller of any kind, and retain their unsold status, which is plainly not the intent of this paragraph.
Is it your contention that what's stated on page 50 about unsold shares conflicts in some way with what's stated on page 657 about unsold shares?
Apologies. Is it my contention that those two provisions are
Are in
contradictory?
conflict, yeah?
I think that it would be impossible to read them in perfect harmony, or put a different way, on 657 or 537, it's the same. It's 38A of the proprietary lease. It amplifies the language on page 50 and imposes additional requirements not found in the language on page 50. And because because RFLP didn't meet those additional requirements as set forth on 657 or 537, the motion should have properly been denied.
Any further questions from me? Thank you.
Thank you, Your Honors.
Pimentel versus DeFreight. You sit in the back chairs. So I understand when I called the case, we had a representative attorney for Namur, for TEI, and for the plaintiff, and we've since a representative for DE Freight has appeared. Is that correct? So I've given you 4 minutes, okay? You are Namur. You represent
Namur, yep.
Namur, is that? If you just state your appearance and begin.
Yeah. Good afternoon. Glenn Kaminska with the firm Omni, Demers, McManus, counsel for appellant respondent Namur. In my limited time, I'd just like to address the indemnity issue that affects my client. And specifically starting with Tranzel. The contract is clear that there's an intent to indemnify. The claim clearly arises out of or is related to Tranzel's work. It's their employee. In fact, they had 3 workers engaged in the activity that was ongoing at the time. So Worth and the other cases that Tranzel cites to avoid contractual liability are simply different on the facts. It's not a situation like in Worth where some contractor who happens to be incidental, the mere situs of the accident. Here, the contractor from whom we are seeking indemnity is the employer who was obligated to supervise and direct the work. I think there's no question that we're entitled to contractual indemnity. We'd ask the court to affirm that holding. As to DeFreight, we believe that we are, or DE Freight, we believe that we are at least entitled to a conditional order of indemnity, common law indemnity. There's no question, again, that Namur has no active fault. That's already been determined. I would direct this court to page 15 of our brief with regard to different facts that show where the negligence of DE Freight exists. 880, 881 of the record, no one was supposed to be in the back of the truck without permission, and importantly, no one was supposed to be on that lift gate. 983, standing on the lift gate was against DE Freight's policies. 974, the driver was supposed to lower the delivery.
Yeah, but if the item was unstable, then that would have been another problem. The simplest thing was to secure it in some way. That's the only reason he was on there. So wouldn't that go, even if he was on there and he shouldn't have been on there, wouldn't that go to contributory negligence?
Well, there you go. I'm talking about the indemnity obligation of DE Freight to my client Namur. You're talking about a 240 issue which primarily I'm going to rely on my brief. But if you want me to address
No,
240.
okay, go, continue with the contribution, the indemnification.
And then finally, I would look to 2085 through 2089 of the record, where Transel's expert certainly shows why there is fault for DE Freight. And with all of that, they are at least 1% at fault. I'm 0% at fault. I'm entitled to contractual indemnity from Transel and common law indemnity, at least a conditional order from DE Freight. And unless this court has any questions, I'm happy to rest on our brief.
Okay, thank you.
Good afternoon. May it please the court. Patrick Wallace for Cross Appellant TEI. We disagree with Namor's contention that this accident arose out of TEI's work. The accident arose out of the failure to maintain the liftgate. The fact that the plaintiff was on the liftgate in it of itself didn't cause the accident. The liftgate was supposed to be able to hold 1,500 pounds. The liftgate failed because it wasn't properly maintained. All that was done to supposedly repair the liftgate was slap on a piece of diamond plating, which was completely superficial, while the underside of the lift plate was completely rusted out. That did not arise out of TEI's work. TEI had no responsibility to maintain the liftgate or the truck. It was solely DE Freight's responsibility. And with respect to, I'd like to address the issue of the 240 finding by the court below. It's our position that this case is similar to Topher and its progeny, that this was a fall off a truck, a 3 to 4 foot fall off a truck, which does not implicate Labor Law 240.
So are you saying that 240 has an absolute number of feet that the worker has to fall in order for it to be an elevation-related fall?
No, it's not that. It's just that under similar cases cited in the brief, including Topher, that a fall off a truck while unloading materials 3 to 4 feet is not considered a Labor Law 240 type of action.
So regardless of the circumstances of the fall?
I think
it's your position that Topher says that regardless of the circumstances of the fall, that if a worker falls 3 to 4 feet off a truck, it can't be a violation of the labor law?
It's not just that. It's just the unloading materials off a truck and a fall 3 to 4 feet. It's not considered an elevated platform. It's not considered a type of injury that's covered under the statute, under Topher. Unless you have any further questions, I'll just reserve my further arguments for rebuttal.
May it please the court, good afternoon. My name is Eric Tosca from the firm of Kelly, Road and Kelly. We represent DE Freight, the respondent and the appellant in these two appeals. Your Honors, I'd like to address the issue of common law indemnity initially. One of the cases cited in support of the proposition that common law indemnity is viable against DE Freight as to Namor was McCarthy versus Turner. And McCarthy versus Turner was decided by the Court of Appeals directly contrary to the proposition that Namor cited. The point is that whether you had responsibility, contractual authority over the work is immaterial in terms of acquiring common law indemnity based on supervision of the work. There has to be the exercise of actual supervision and control. That's entirely absent here. TEI undertook that delivery. They undertook the delivery. The driver, DE Freight's driver, was not there. He left. They took responsibility for the entire delivery, operating the truck.
Is seeking common law indemnification and contribution from you, right?
Yes, Your Honor.
Why are they not entitled? And that motion was denied below. To that extent, what supports denying that motion?
The denial of the motion is based on the fact that there's an open question as to the negligence of Namor. I'm sorry. I apologize.
There's an open
I misspoke. The negligence of DE Freight. So Justice Bluth found that DE Freight was not negligent as a matter of law, which they're not. And indeed, we're arguing on our appeal that the case should be dismissed because there's no notice. Now, there has been no finding of negligence. Unless there is, it's premature to
Well,
award
when you
any
say
kind
there's
of...
no notice, is there no constructive notice? After all, the truck had problems, the liftgate had problems before. Had recently been sent for repairs, and when you look at the pictures of the liftgate, it certainly looks very rusted out underneath. So obviously, the repairs that were done would seem to have been inadequate.
I disagree, Your Honor. And the reason I say that is because Mr. Joseph, the principal of DE Freight himself, after the repair was done, inspected it, tested it. There is not one party in this...
He tested it with heavy toolboxes, right?
Yes, and
He
also
didn't test
inspecting
it-
the...
Did he test it with something weighing hundreds of pounds?
No, but he did inspect it, the underside, he looked at it. There's not one solitary person who said there was any problems with that liftgate after it was repaired. Now, the repair...
Except that it clearly fell.
I'm sorry, Your Honor?
Except that it clearly fell. It wasn't supposed to fall. It clearly fell without the weight that it was supposed to be able to hold.
At the time of the accident, the question is, what kind of notice did we have? The inspection was done. DE Freight's superintendent at the site said he stomped on the gate, or at least Mr. Pimentel testified that he stomped on the gate. There could have been a number of things that have happened since the repair was done. The point is that it was inspected, it was tested, there was a smooth ride before the...
I guess that goes back to the question of how it was tested, and not putting a weight bearing of the amount that it was meant to take is not exactly an adequate testing.
Except we have no testimony from anyone, not even the experts who say that.
What we do have is that,
if
I could just, what we do have is that the test that did take place, that you just said, was not of the weight that the lift was supposed to bear. It was of something much less.
Your Honor, I think we need an expert who can say that this testing was inadequate, and nobody has testified to that.
If DE Freight is not let out of the case, why wouldn't Namur be entitled to indemnification from DE Freight if DE Freight is found negligent?
If they're found negligent by a jury, then they may be entitled to common law indemnity, but there are other factors that are involved here, Your Honor, and that is the superseding intervening cause that they violated. The personal injury arising out of this is completely unforeseeable. The warning signs were completely violated, Your Honor, by the people who used this liftgate. So that's not something that was foreseeable. So as a separate ground, we believe that the use of the gate, the misuse of the gate, by Namor's own expert who said, and he doesn't fault, by the way, DE Freight, Mr. McPartland, he doesn't fault DE Freight for this accident. He faults the contractor, TEI, only, specifically, only.
Thank you.
Okay, thank you, Your Honor.
May it please the Court, Michael Zhu, Appellate Counsel to Short Staffel Lawyers, attorneys of record for the plaintiff respondent, Francisco Pimentel. Judge Gessmer, I wanted to get back to your question. You asked before on Topher whether any circumstances involving a fall off the back of a truck negates the applicability of 240, and it doesn't. So Topher, Berg, Bond, and this Court's decision in Deluvio are all not applicable because the facts in those cases involve a worker simply falling off a truck. Here what we have is we have a worker who's standing on the back of a liftgate. The liftgate was being used to hoist materials and equipment off a truck. The liftgate collapses while it's on its way down. He's standing on the liftgate with his foreman, working with his foreman, and he has a superintendent on the floor. So any argument that the plaintiff was recalcitrant for failing to obey an instruction to avoid standing on the liftgate makes no sense because he was there with his foreman and he was following his foreman's instructions. There were no instructions for him to not be on the liftgate. As to the argument that there was a ladder nearby, there's no evidence or testimony that the plaintiff was aware of the ladder, that he knew to use the ladder, that he was instructed to use the ladder, and for no good reason he failed to use the ladder. We believe that the collapse of the liftgate itself was a safety device, which causes him to fall to the ground, establishes a prima facie violation of the labor law. And once you have that, it's conceptually impossible for a worker's negligence to be the sole proximate cause. So on that basis, as the sole proximate cause defense and the recalcitrant worker defense are not applicable, we submit that the court should affirm the lower court's finding of partial summary judgment in favor of the plaintiff. Unless there are any other further questions, I'll rest on my brief.
Thank you.
Thank you.
As to 240, I will simply say this. Issue finding as opposed to issue determination is the key with all these motions for summary judgment. And here, this is not the type of case that calls for one of the devices in the statute. The court specifically found that this was not a safety device. And this is really the usual and ordinary risk undertaken at a construction site. And while Topher doesn't give you a hard line rule to say this height is 240, this height's not 240, it does say in the circumstances under Topher, which is not a circumstance where he was just standing around on a flatbed, but he was struck with a lever while they were unloading steel beams. And in that case, at a similar height, it was not 240.
Doesn't the record support that the reason that that Mr. Pimentel stood on top of the liftgate was to stabilize the load? And the load, I assume, was of some value, because it's what they were waiting for in order to do the next step of their work. And if he had not stabilized it and it had fallen, that wouldn't have been good for the work either. So I don't understand how he could have done his job without standing on the liftgate.
Well, he could have simply put the A-frame onto the liftgate and lowered it. Had it damaged the goods,
what would have
we
held
would have
it?
damaged goods, but we wouldn't have a damaged worker. And we have to make a determination somewhere along the line, right? We got to say, hey, we want
With his
the damaged goods, not the damaged workers.
His foreman didn't stop him from standing on the liftgate, so presumably the choice had been made as to whether the worker or the goods should be protected, right?
I understand what you're saying, and I'm saying at 4 feet, I don't think they really were making that determination. I think they were determining this is kind of a usual and ordinary circumstance with a 150-pound item that's really not that, it's not an 800-pound spool and runner going down, stairs. I apologize. Thank you, Your Honors.
I'd just like to address the comment by DE Freight's counsel that the evidence if anything, the evidence points to a fault of repair by the company that it hired to repair the liftgate. That does not in any way relieve DE Freight of responsibility, because DE Freight was solely responsible for the maintenance and repair of the liftgate. The fact that the repair was not properly done is evidenced by the catastrophic failure of the liftgate, basically the first time any kind of substance weight was put on it.
Your position on behalf of TEI that at a minimum you want contribution from them. If you have to pay, they have to pay too. And it's not really your issue, but isn't that also true vis-a-vis Namur?
Yeah, well, I think, well, it isn't our issue, but our contention is that this accident was solely caused by the failure to properly repair and maintain the liftgate. So to that extent, it's clearly that it was DE Freight's responsibility, and they can't avoid liability by simply saying, well, somebody else did the repair. Somebody that we hired did the repair because it was their responsibility to do so. Thank you.
Thank you. Thank you all. People versus Roderick Kovlin. Justice Gesmer is recused from this case. Obviously, you're aware of that as you made your motion earlier.
Thank you, Your Honor. Good afternoon. May it please the court, my name is Stephen Feynman. I represent the appellant. The appellant was convicted as a result of extensive prosecutor misconduct that occurred both before and throughout the appellant's trial, which the people in the respondent's brief have simply ignored. Since I have limited time, I would like to briefly mention three of the most egregious examples of it, and then I'll discuss them in more detail. The first of which was the blow-up, manipulate version of Ms. Kovlin's apartment, which was never, of her bedroom, which was never admitted into evidence. The first time the jury saw the manipulated photograph was at slide 143 of the People's PowerPoint presentation. The slide was the basis of the new theory of the People that was created by the prosecutor in his summation to solve the most serious flaw of the People's weak circumstantial evidence case, that there was simply absolutely no evidence that the appellant was ever in Ms. Kovlin's apartment before 7:04 in the morning of December 31st, 2009.
Well, isn't it, at the end, the people's theory of the case rather straightforward? There's, after all, camera surveillance, there's door-person surveillance at the building. No one else is spotted going into the building at the pertinent time. The defendant, there's evidence that the defendant had access to the apartment. Ultimately, there's evidence that the victim died as a result of a chokehold. And the only person who had access to the apartment and access to the victim is your client. So it sort of follows pretty easily that the perpetrator of the crime is your client. And the evidence is pretty overwhelming in that regard.
All due respect, I strongly disagree with that analysis, Your Honor. Access is not means. There's absolutely no proof that he was ever in the apartment before 7:04 on the morning of December 31st. It's a large apartment complex. There's over 684 apartments. There was hundreds of people who could have accessed the apartment and the doorman.
Who had a key to the apartment? Now, I know that you deny that your client had a key to the apartment, but the people presented evidence that he did have a key, or at least that there's reason to believe he had a key to the apartment. And when someone has difficulty getting into the apartment because they're having trouble operating the lock, the one who doesn't have a problem operating the lock is your client.
Well, a key, again, is only possible evidence of access. There was absolutely no evidence he was ever in the apartment. And according to the claim that everybody was having difficulty, it was basically not a new lock. It was a lock that was on the door for approximately 9 months already, and no one has ever claimed that anybody had difficulty entering the apartment. But again, the fact that he might have had a key, that there was hearsay testimony, that was possibly...
You want us to believe that there's some intruder that entered that apartment?
It's the people's responsibility, the burden of proof beyond a reasonable doubt, to establish that my client had the means to commit the crime. They have not submitted any evidence to satisfy their burden of proof.
Sir, was there any evidence of a forced entry?
No evidence whatsoever.
So no forced entry. Your client had the key. Your client could open the lock with ease. Your client was in the building on that date and time. There's motive throughout the record, and there's no basis to find that your client is guilty?
And let's add to that, that your client is a martial arts expert and that the victim died as found by the autopsy from a chokehold.
Okay, as to,
Which he has been known to boast to others that he can kill someone with a chokehold.
And I misspoke when I said guilty. I meant to say that there was not proof beyond a reasonable doubt.
okay, as to Justice Renwick's question, with regards to the hearsay testimony, that was an admission that appellant had a key. In that same statements he made to these one or two individuals, Miss Robin and Miss Johnson, they stated
They're not hearsay if there's an exception, of course.
okay, but they stated that the daughter let him into the apartment. One, that the daughter unlocked the door and took the chain off the door.
Right, we're talking, he said himself that he had a key to the apartment. So we don't need to go to whether the daughter said something or someone else said something. He has said things, he had made statements himself that he had a key to the apartment.
But the same statements he said that, the next clause was, my daughter let me into the apartment. My daughter opened the lock. My daughter took the chain off the door. With regards to the question concerning that he was a martial arts expert, there was absolutely no evidence in the record that he was an expert in martial arts. The only evidence was his bragging that when he was a child, he took a martial arts class, and when the instructor...
He told one of his friends, and just to the other thing, I thought that there was someplace in the record, and I may be wrong, that Oleg, or the girlfriend Oleg, that he had told her that he had a key to the apartment, separate and apart from the child taking the chain off the door. But with regard to the instance that you're just speaking to, I'm sorry, would you repeat?
Martial arts.
Martial arts, right, thank you. He commented to his friend, he wasn't talking about simply childhood, he indicated the present ability to kill someone with a chokehold.
Well, those are social occasions that happened years before, but I also want to stress that according to Dr. Hayes, anybody can commit a chokehold. We all have seen chokeholds on TV, in the movies, on wrestling. According to Dr. Hayes, who's
Well, that might be okay for other people, but not those who brag about having expertise in Taekwondo.
Taekwondo, according to the evidence, you don't teach chokeholds. You don't teach chokeholds in Taekwondo. But I want to stress that.
Well, I think the jury was able to rely on on the testimony that they found credible, obviously, the testimony of people who repeated his statements as statements against interest that he knew how to kill someone with a chokehold because he was a martial arts expert.
Again, I don't believe there's any evidence that shows that he was an expert in martial arts. I believe there was just simply, there's absolutely no evidence in the record.
Well, not an expert, I'll take that back, that he knew martial arts. The jury heard this. The jury heard the statements. The jury was permitted to accept it as credible.
I see my time up.
May it please the court, Beth Fish-Cohen for the people.
Counsel, this wasn't a perfect case. There seems that there was, evidence that went in that probably shouldn't have gone in. What do you have to say about those items?
So, specifically about Molyneux evidence, are you referring to, or?
We'll start there.
Okay. So there's a certain amount of evidence that I think there's absolutely no question was necessary to understand the deterioration of the relationship, the motive.
It sounds like what you're telling me is that, some evidence that doesn't belong in the record can go in for background, and that's not an exception.
No,
Background.
Your Honor, that's not what I'm saying. There were certain major triggering events that led to her death that were essential to the jury's understanding of the case. So not only is it an understanding of the way the relationship has deteriorated and the specific motive and intent that related primarily to finances and custody, but also here there was highly probative evidence that one event led to another. So for example, the very first day that they appear in court for the divorce proceeding is the same day that he makes an allegation to the victim's employer that she is using drugs and stealing from him. The ability to hack into her email and her phone was directly relevant to the understanding that the day that she is killed is the day that she is to meet with a lawyer about changing her will. The fact that the defendant did not return the children pursuant to a custody agreement and made false accusations of sex abuse led to supervised visitation, which was a big motivating factor in terms of the defendant's animus and rage toward the victim. So it was a provident exercise of discretion to admit the evidence, and there was not admitted under some blanket theory that everything that's domestic violence related came in. The trial court's decision went through each piece of evidence, precluded much probative evidence, and decided why different evidence was admitted on different theories.
Well, let me ask you this, which I think goes to the weight of the evidence. The babysitter, whose name I can't recall, Ruth, maybe?
Rose.
Rose testified that she came in there and she was on the floor and she explained that she had been hit by the husband, that's why she was on the floor. Then Eve, her sister, testified about the same thing. Then the attorney testified about the same thing. So what was the basis if Rose's came in for an excited utterance? What was the basis for Eve and the attorney?
Well, one of the reasons for the attorney was specifically that also went to the defendant's state of mind, because the defendant was aware of every allegation that was in the divorce proceedings. So that went specifically toward his understanding of what was happening, his motivation, and how these things escalated in an 8-month period leading up to her death.
Whose understanding?
The defendant's the allegations that were made in the divorce proceedings were, of course, read by the defendant.
Let me just ask you something. Wouldn't the testimony that came in through Eve, who heard it later on sometime over the phone, and the testimony that came in through the attorney who heard it, I can't even remember when in relation to when it happened, days, weeks, whatever it was, wouldn't those things, shouldn't they have been excluded from the testimony?
There was evidence that was admitted either through excited utterance exceptions or through state of mind exceptions. As this court is well aware from Brooks, there can be, if the majority of the evidence is admissible and there are specific things that either should not have come in on hearsay grounds or because this court feels that the prejudice outweighed the probative value.
The people were helped in presenting their case by the fact that the defendant, by putting a keylogger on the victim's computer and phone, put himself in a position that he knew everything that was going on with her correspondence, subjecting him to the admission of evidence which might otherwise not have been admissible.
Yes, Your Honor, that is true. There was evidence that came in because this was so probative of the different circumstances that would come after the fact. So what I was trying to say in response to Justice Renwick's question is, there's no doubt a tremendous amount of evidence came in. If this court were to find that certain things should not have come in, whether it was because of hearsay or this court disagreed with the probative versus prejudicial balancing, it does not entitle defendant to a reversal of the conviction.
You're saying it's harmless?
Yes. So I don't mean all of this evidence should not have come in. I mean that the bulk of it was properly admitted, as in Brooks, but if there are specific items that maybe this court felt were cumulative or were not used in the manner that the court intended with the limiting instructions, that did not alone, based on the overwhelming evidence of guilt, entitle defendant to a reversal of his conviction. The people continue to submit that the majority of evidence was properly admitted, was a provident exercise of discretion, and fit in both either under was not offered for its truth or was admitted during a hearsay exception and was relevant to the issues at trial. Another thing that I think is worth mentioning, not only is this a case where the defendant, where this evidence is critical to pointing to the defendant's identity as the killer to the exclusion of other people, the defense continued in summation to argue that this was an accident, that there was insufficient proof that the death was not a tragic accident. I submit that that defense was yet another reason why it was important for the jury to hear everything about the proper context. Also, this is a case where the defense in summation called it one of the most botched, incompetent, disgraceful police investigations in the history of the world. So putting aside the hyperbole, this is one where it took 4 months for this to be declared a homicide. There was no crime scene. There were tremendous obstacles from the outset of this case. So the fact that that is yet another reason why this evidence was so important. As this court has said repeatedly, evidence can be brought in to make something explainable that would not otherwise be explainable. That if something seemed suspect, such as the fact that a person who has an order of protection may also give a defendant a key to an apartment. That's a critical piece of information that was established both through the help of a domestic violence expert who explained why a situation like that might occur, as well as this testimony admitted partly through party admissions as well as through other facts of the case, showing that the defendant had means to access the apartment with a key. I see my time is up. Thank you very much. We rely on our brief for the remaining points. Thank you.
The people in their brief simply ignore the fact that Brooks, before the trial even started, extinguished the background hearsay section of Beerenbaum that was created in domestic violence cases. They ignore the fact that the prosecutor falsely told the jury that not only did Brooks did not extinguish the background hearsay exception, but in fact created a whole new, much broader state of mind background hearsay exceptions for domestic violence cases. According to the prosecutor on the first and second page of his Molyneux motion, he explained how much evidence he needs to present in order to establish their case. He indicated that the evidence consisted of over 732,000 emails, over 100,000 text messages, over 6,000 Facebook messages, thousands of pages of internet searches, forensic examinations, and several devices, hundreds of documents that consist of thousands of pages, testimony over 50 witnesses, photographs, video, and audio recordings, charts, and graphs. If it wasn't for this highly inadmissible propensity evidence, that was almost all of it was submitted under Beerenbaum and the false representations of Brooks, this trial would have been a week and a half, 2 weeks long, not approximately 2 months as it actually occurred. With regards to the—
Sir, how do you answer your friend's point that much of that evidence, or at least a substantial portion of that evidence, was designed to rebuff the defense that this was an accident or this was the act of someone other than the defendant?
That was a false representation of the evidence. This is nothing like Brooks. In Brooks, the defendant, the people's theory in Brooks was that the defendant killed the victim in a homicidal rage when she told him she wanted to break up with him. So all the evidence was admitted to rebuff his defense. In this case, the defendant didn't deny that he was a bad husband. He didn't deny that he used his wife's money. He didn't deny that he loved backgammon. That was the people's theory of the case. They totally ignore most of the appellant's briefs, brief that consists of hundreds of pages, as you know, talking about all this misconduct. I've never seen the abuse that's occurred in this matter. With regards to the video in this case, it was admitted not based upon any evidence. There was no foundation that was established. It was just based upon two redacted documents, an affidavit and a letter, which it's allegedly was drafted by an unidentified inmate and the documents were never authenticated or admitted into evidence, so they had absolutely no evidentiary support. May I continue?
Yes.
Have absolutely no evidentiary support, and the prosecutor was able to use these inadmissible documents as a basis to admit the signed surveillance video on false representations and false statements that somehow these inadmissible documents were reliable. And because they're reliable, they somehow established that the video shows the appellant confessing to the crime to the inmate and demonstrating how he committed the crime. I mean, there was absolutely no legal basis.
Did Correction Officer Rodriguez adequately authenticate that video? There wasn't a verbal portion. It's a demonstration of how the defendant knew how to do a chokehold.
No, I disagree with you, Your Honor.
There was sound? Was it a sound accompanied
No, but there
with
was
the video?
there was a discussion throughout the whole video.
But the jury couldn't hear any discussion. All they saw were the actions, right?
Well, that they saw the conversation, they saw the actions, but according to
Weren't they told to disregard the conversations, which they didn't hear? The fact that they're talking, the jury didn't hear the conversation.
According to well-established law, even the cases they cite, which they basically contradict their own position. According to the law, in order for the jury to view a signed video, you need a participant, someone with personal knowledge of the conversation and what is depicted on the video,
but the
to testify to the jury.
conversation isn't admitted.
I'm sorry, Your Honor?
The conversation isn't admitted to the jury.
And what was depicted was clear. They watched it.
It's very possible if the prosecutor called, the only person who could possibly, I would argue, could possibly admit the video, could create a proper foundation for the video, was the inmate. But since the inmate repudiated the allegations of the letter and his affidavit, they refused to call him. It's very possible that he could have simply said to the jury, I asked the appellant what was the people's theory of the case was, and he just showed me. That's why it's, according to well-established law, you need someone with personal knowledge.
Is that what happened here? The video shows the defendant demonstrating a chokehold.
That is what the prosecutor, basically, through hearsay statements to the court, claims to have occurred. There was absolutely no evidence in the record.
Didn't they have an expert? I don't know if the expert talked about that.
There was this just established the additional prejudice of the video. Without any personal knowledge, two experts were called, and through leading questions, the prosecutor got the exact testimony he wanted.
But there was a limiting instruction that spoke about the jury only taking that, not making any assumptions about what might have been said or about what conversation, only to look at the video for the simple act that was occurring.
The instructions was far more prejudicial than The judge simply said, don't speculate that he's confessing to the crime. Don't speculate that he's demonstrating how he committed the crime. By telling the jury not to speculate, they speculated. In addition, there was not a single witness who had...
Is there an objection to that charge?
Yes. The defense counsel said the only person who could testify so there wouldn't be any speculation would be the inmate. But again, the prosecutor refused to call the inmate because he repudiated the letter and affidavit, which was never admitted to evidence, which the prosecutor used as the basis for the admission of the video. These errors are...
What did Correction Officer Rodriguez testify?
He testified.
And what did he testify to?
He only testified as to authentication of the process, but by that time, the defense counsel made on 4 different days in a letter application to the court objections that the video cannot come in because it was not properly authenticated and a proper foundation was not established. So by the 5th time, when the judge asked him, "Do you have any objection?" the defense counsel said no. He already objected 4 times, and I would say for hours, if you read the actual transcript. And there's cases, I could cite you the cases that says that once you object, you don't have to continue to object. You're just going to antagonize the court.
Thank you.
Okay, thank you, Your Honor.
Thank you. Thank you both.
Thank you. Sorry, it's taking me a while.